Good morning.
Good morning, Your Honor.
Welcome to this continued session of the July 2021 oral arguments before the Kansas Court of Appeals. My name is Sarah Warner, and I am the presiding judge for today's proceedings. Before I call this morning's case, I'd like to take a few minutes to introduce the other members of our distinguished panel of judges. First, Judge Amy Klein comes to us from Wichita. And then Judge Richard Walker, who has served as a senior judge on our court since 2015, joins us from serving previously as a district court judge in Newton. In preparation for today's argument, we have thoroughly reviewed the briefs that you have filed in the court record, along with a legal memorandum that has been prepared by a research attorney. So we are familiar with the facts of the case, but because this argument is streaming online and is going to be archived as a standalone video, I've asked appellant's counsel to provide about a 1-minute factual summary as to how we got here and what the issues are before us before we delve into today's argument. The case before us is scheduled to allow each party 15 minutes of argument. I will be keeping time, including any rebuttal time that is requested by the appellant. With that, at this time, I call case number 121978 from Dickinson County, Alma Belmore appellee versus Margaret Goldizen and Jay Goldizen appellants. Will the parties please state their appearances?
Good morning, Your Honors. The appellant in this case, Margaret Goldizen and John Goldizen, appear by means of a Zoom connection. I'm Peter Rombold of the Hoover Law Firm in Junction City, representing the appellants. Margaret is also with me here in the law office, appearing by means of this Zoom connection.
Appellee Alma Belmore does not appear in person, but appears by and through counsel Melissa Richards.
Thank you. Mr. Rombold, would you like to reserve any time for rebuttal?
I would like to reserve 5 minutes rebuttal, please.
5 minutes are granted, and you may proceed.
Your Honors, this case arises out of a family dispute between the family members of, I believe the rules require that I use initials, Alma Belmore, hereafter AB, where the children of AB sued their sister and her husband, Margaret Goldizen. In this case, prior to this case, also in the state of Washington, on the grounds that my client abused her relationship with her mother to her own benefit. The instant action was an action seeking to recover rent, personal property, and real property. There was an allegation that this property had been converted to my client's own use, and that my client had breached her duty as attorney in fact, also breached a contract and sought recovery for rent. Award of attorney fees was also sought. There was at least a 4-day trial. I think actually it was a 5-day trial in the district court on this. The record was voluminous, and some months thereafter, Judge Rozier issued a 12-page memorandum decision, single-spaced, substantially granting the plaintiff's request in all respects, and this appeal followed. We have briefed the issue extensively. I thank the Court of Appeals for permission to expand the page limit otherwise that would be otherwise applicable to briefs. It was necessary. The record was voluminous, and the also request to accommodate my absence from the office earlier this month. I appreciate that very much. I hope this adequately summarizes why we're here today. I'm prepared to proceed. Again, I do ask for 5 minutes rebuttal.
You may proceed, counsel.
Thank you, Your Honors. In our brief, Your Honors, we gave the court 51 paragraphs of detailed citations to this voluminous record. It's found in pages, of course, 6 to 26 of our brief. My understanding in the Court of Appeals that the respondent's brief, the appellee's brief, should be somewhat responsive to the allegations, to the points made in the brief. There was, however, no correspondence in the statement of fact filed by the appellee to our statement of fact with citations to the record. I find, as I reviewed it, that the appellee's brief sounded very much like the closing argument made to the court sometime after we concluded this case. With deep respect to the court below, a very earnest and hardworking judge, and to my colleague, whom I have all the respect in the world for, I am compelled to bring this appeal because of my obligations to the court as well, and to the whole theory of stare decisis. We have a judgment in this case that has little to no correlation, and I don't say that lightly, but very little correlation to the factual record in this case. As for the applicable evidentiary standard, I humbly submit that regardless of whether or not you use the lowest applicable standard, which would be, of course, preponderance of the evidence, that this decision would have to be reversed even under that standard. But that's just for the sake of argument. I don't submit that the evidentiary standard in this case is preponderance of the evidence. There is no substantial competent evidence in support of any finding that AB was incompetent or subject to undue influence.
Counsel?
Yes, ma'am.
Is it your position that there is no evidence to support the district court's findings, or is it that the district court's findings are not supported by what you find is the compelling evidence in the record?
I believe the only evidence that is in this record in support of a finding that there was undue influence would be the testimony of Ed Belmore, the son of and presently guardian of AB. There is no other evidence, Your Honor, that would be consistent with the finding by the court that AB was overcome, was subject to undue influence, was incompetent, had no ability to execute the deeds or grant my client an interest in these accounts. That the only other evidence, of course, would be a statement by Tisha Watley. This was the estranged granddaughter of my client, Margaret Goldizen. Ms. Watley, however, on the record, when asked to explain how in the Superior Court of Pierce County in Washington, she could be very supportive of the contention that it was Ed Belmore and George Belmore that were exploiting their mother, how she could testify a couple of years later it was just the opposite, that it was Margaret Goldizen and John Goldizen that were exploiting AB. And Ms. Watley explained very blithely that, well, truth changes over time. On the record, of course, truth doesn't change over time. And I do not consider Ms. Watley to be a credible witness because of that admission on the record. And quite frankly, I'm surprised that the appellee put that evidence in their briefs in support of the contention that my client was guilty of misconduct. So that is why I say Ed Belmore only.
The reason that I asked that question is that because the appellate judges weren't present at this lengthy evidentiary hearing that was held, I mean, our hands are somewhat tied in terms of our standard of review, right? We can't reweigh the credibility of witnesses, even if if we would have been sitting in the district court's position, we may have come to a different conclusion. So we are simply called on to determine if there is some evidence in the record to support those findings. And so that's what I'm trying to figure out is it your contention that there may be some evidence, but it's not good evidence? Or is it that there is no evidence?
There is some evidence, and that would be Ed Belmore. However, when you look at the quality of the contra statement, if you will, that is those statements and assessments that AB was competent, was not subject to undue influence, express concrete statements to that effect, which you find in the record from the psychologist at Prairie View in Newton, Kansas, that you find from her personal practitioner, Heather Blesser, a doctor in Abilene, Kansas, that you see from an experienced probate attorney, Bruce Wingard of Clay Center, Kansas, and even the testimony of Dr. Christine Durrett, who, although she didn't examine my client, nonetheless was able to do what she called a case conceptualization. This be another word for record review, and found that she couldn't put AB on any one point in the spectrum of dementia, which is a progressive disease, of course, and why she couldn't say where she was at any one time, recognized the reputation of Prairie View and Newton, agreed with the assessment that AB was capable of handling her financial affairs, and furthermore, unbidden, actually I didn't think to ask the question, stated that she found it be very unlikely that AB would be susceptible to coaching, stated that on the record. Those are material, concrete, very specific, and inclusive statements as to the capacity of AB at that time. And Mr. Belmore disagreed with it. Mr. Belmore felt like, well, Ms. I do want to call her name, AB gave inaccurate information to Doctors Pierce and Blesser and Wingard and the like. But what Ed does not, Mr. Belmore does not understand that psychological evaluation conducted by Prairie View, it was objective and subjective. These tests that are given, it's like sitting for an entrance exam. There's a certain list of questions they're given. There was 3 batteries of tests administered to AB, and there was a score. And indeed, the testing at Prairie View indicated there was some dementia. There's nobody that has said on the record, any competent witness has said that there wasn't some evidence of some decline. I mean, we all get less sharp as we go on and get closer and closer to the sunset. But to suggest that because when we first have evidence of cognitive decline, that we therefore immediately become incompetent and incapable, and therefore completely dependent upon whoever has us in their control at the time. I think there's many families in Kansas, and particularly grandma and granddad would find a lot of problems with that, and would disagree. And that's, yes, sir.
As experienced counsel, you know that every day judges are called upon to decide when somebody says, yes, it happened, and somebody says, no, it didn't happen, who's correct and who's credible on that. Credibility determinations are the stock and trade of judges. How are we able to, and this is related to what Judge Warner, and I read Judge Rozier's opinion, and it's very clear that on a number of key points, he simply found that your evidence, for one reason or another, lacked credibility. And how are we able to say, well, Judge was there, Judge was, but he was wrong. He should have believed this. I mean, how can we possibly do that when that's what we ask judges to do every day of the week?
Well, again, I don't want to wear out this part of the evidentiary record too much, but those assessments by the MD, the PhD, and the JD they were very concrete and opposed to the determination that the judge made. The judge actually even found that she was incompetent earlier than 2016, contrary to the determinations made by the psychologist and the MD and the JD in 2016. And the only thing he could have based that upon would have been Mr. Belmore. As far as the credibility determination and assessment, there is another very important piece of this record that didn't merit mention by Judge Rozier, and that was the deposition of Ms. Karen Lemieux. Karen Lemieux had known my client, had been her sister-in-law, a friend and sister-in-law of AB for 60 years, was not in the control of any party and the like. She knew very much what her friend wanted to do. She was, and this was an evidentiary deposition. It's Exhibit 100. It's in the record. And she states very clearly that AB had no intentions of staying in Washington, wanted to come back to Kansas, didn't want to have anything more to do with her sons, who considered her to be an ATM machine. And as far as, she also spoke to issues that are as to undue influence. If anybody was being isolated, Karen Lemieux was wondering whatever happened to her friend. Her friend was still nearby in the state of Washington, hadn't heard from her friend since she was brought back to the state of Washington. Couldn't call her, received a phone call stating that she'd like to get together, and then the phone hung up. I mean,
Counsel,
yes, ma'am.
we're running into your rebuttal time, so I just wanted you to be aware. So we could either stop now and reserve that time for your rebuttal, or you could keep on with
well,
your.
All right. I hope I did a good enough job with the facts and the brief. I will, in my 5 minutes, talk to applicable legal standards and case law. Thank you.
Thank you, counsel. Ms. Richards?
May it please the court. Good morning, Your Honors. This case is simply an attempt by the appellants to ask the court to reweigh evidence. When Mr. Rombold was asked by the court if there is any evidence supporting the lower court's decision, the answer was first no, and then, well, but yes, there was some. I would submit it's not just the testimony of Ed Belmore. There was plenty of evidence in this record to support the court's decision. But what they're really asking you to do is look at the evidence and reweigh it and say, nope, you should have listened to these witnesses instead of these. And you should have found these witnesses more credible than these others. And defendants' witnesses had better information. And that's not what this court's job is. This court must look to see if there is substantial competent evidence to support the court's decision below. And we would submit that the record is replete with that information. It's replete with numerous witnesses that testified. As Mr. Rombold stated, we had I believe we were scheduled for 5 days. We ended up at 4 because former President Bush died in the middle of our trial, and so we were closed for 1 day. But we stayed in the evening several times to make up for that. So it essentially was a 5-day full week trial with hundreds of exhibits. There's certainly plenty of evidence to support the decisions that the court made here. And it's just not proper to ask this court to reweigh and make different credibility decisions than Judge Rozier did.
Counsel,
I think,
can we, before we start discussing the evidentiary record, can we talk a little bit about the question of the guardian ad litem or the substitute plaintiff?
sure. That was a question of, I think everyone was looking at what was best to do in this particular situation, which was a bit unusual and new to all of us, including Judge Rozier. And what he determined was that a substitute plaintiff, who was Catherine Kraft, an attorney practicing in Salina, who does often serve as a guardian ad litem, had a good history and experience to serve in that role. And so she was appointed as substitute plaintiff, reviewed the record, met with Alma Belmore and several of the witnesses, and participated in this case to the fullest extent that you would expect a plaintiff to.
And was when Ms. Kraft was appointed substitute plaintiff, is that essentially a next friend of of Ms. Belmore, or what exactly was her role?
Essentially, yes. It was as next friend to, as I see the role, to make sure that this case was proceeding in Alma's best interest and in a direction that she would want it to go. I take issue with the statement that Alma's children sued Margaret and John. It was Alma Belmore that sued. She signed a petition. She was very involved in the case. But as the case went on for over the course of a year or so, or more than that, her mental faculties continued to decline. And we reached the point where everyone agreed that it was best that we take some additional measures for her protection.
Counsel, did anyone object to the appointment of Ms. Kraft as the next friend or representative for Alma in this lawsuit?
If the question is whether that particular attorney serving, no. I believe that the defendants wanted her role to be as a guardian ad litem and not as substituted plaintiff. So there was some dispute about what that role should look like. I believe Mr. Rombold wanted her to do an investigation and a report in a guardian ad litem role. But as far as her qualifications to serve in any role, particularly Catherine Kraft, no.
I don't find in the record any motion to appoint a guardian ad litem. Am I missing something?
I think the difficulty with that, and I believe I addressed that in my brief at one point, but a lot of this discussion about how to properly handle this occurred at a hearing and was on a record that we didn't get a transcript for. So I believe the defendants had filed a motion for some psychological testing. And
under Rule 35, right? Discovery motion for a mental examination, but not an appointment of a guardian ad litem.
Not to my recollection, correct. And this discussion and that decision came about through discussion in a hearing between counsel and the court. And ultimately it was the court's decision that it was most appropriate to proceed with the substituted plaintiff.
And that decision occurred before the trial, is that correct?
Correct.
And I don't see anything in the order, the April order that was appealed, that mentions that issue. Am I missing something?
The memorandum decision from the court in April?
Correct.
Correct. I don't recall him addressing that, no.
Okay. I'm just trying to figure out how we have jurisdiction over the third issue if it's the order, the final order that's appealed doesn't even address the guardian ad litem or the appointment of Ms. Kraft or anything that was raised in this third issue. I mean, do you have can you help me out with that?
I would agree that that's problematic. Ms. Kraft was appointed months before trial. It was not addressed in the court's final order and memorandum decision because at trial, that wasn't an issue. It had been in place for some time, and I don't recall that being argued as improper.
Of course, this would be the first opportunity that we would have to review it, right? One way or another.
I would assume, I don't recall of that. It's been a while since I looked at the statute, but I don't recall that it allows for any type of interlocutory appeal, but I would assume yes, that this would be the first opportunity.
And no one petitioned to appoint a guardian or a conservator for your client as an impaired adult under 59, 30, 58, correct?
Correct. No one submitted a petition to appoint a guardian or conservator. There was a power of attorney that was in place that did name Mary Poulin and Ed Belmore's children as power of attorney in fact, starting, I think, in February of 17. There was recently a limited guardianship case in Washington state, but that's been within the last few months, long after this case was tried.
Judge Walker, did you have a question?
Yeah, just very quickly, what's your opinion, and Mr. Rombold can respond to this too. What's your opinion about any effect that this Washington state litigation should have? Does its dismissal make it just a nullity, or is there something there we need to consider?
Our position is there's nothing there that needs to be considered. Washington has, in this procedure in Washington, for that case that happened in 2016, is essentially akin to a PFA for elder abuse, and that it did not deal with any particular property and determining whether property should be set aside. The issues just were completely different. And many of the actions that the defendants took that were subject to this litigation took place after that case was concluded. So while the parties may have technically been the same, and that it was Alma Belmore and Margaret Goldizen, it was not the same issues, and dealing with Kansas real estate in that case just wouldn't have been proper as well.
Thank you.
Have I answered all the court's questions and able to move on? Okay. I think the other big issue here is that there is a desire to equate undue influence and incompetence when that's not necessarily the case. You don't have to be incompetent to be unduly influenced. And then there's the third issue of the violation of duties as attorney in fact. So even if the court were to look at the appellant's arguments and say, okay, we think that maybe some evidence somehow, which we still argue would be improper, but we think there's some evidence there that she was competent at some point. I disagree with the characterization of the testimony of Dr. Durrett, and of course the court can read that testimony, it's in the record, but she didn't necessarily agree with prior assessments. She said she didn't have any evidence in front of her to disagree with them. And that may seem like a small difference, but it's a big one to me. She didn't say, I agree that this is absolutely spot on, the condition that Alma was on at that time. She was able to put her on the spectrum of dementia and state at what phase of dementia Ms. Belmore was in. And I think the evidence before the court below was certainly competent evidence that she was subject to undue influence, even if she was not incompetent to the point where we would say she can't sign a contract or something of that nature. There was certainly evidence that she was subject to undue influence, and she was unduly influenced by Ms. Goldizen. And it's virtually uncontested that Ms. Goldizen violated her duties as attorney in fact. Her only excuse was, I didn't know. And just the process of putting her name on accounts and putting her name on deeds violated her duties as attorney in fact. And there's really no dispute that that happened. So we can't ignore that piece of the case either. I think that's essentially what we would like to address with the court today. If there's something I haven't addressed that the court had questions about, I would certainly entertain those.
Are there any other questions from the panel?
I don't have any.
The only one I have is, was there actually an adjudication on the merits in that Washington case? I mean, the record is kind of slim on what happened. It seemed like there were a lot of paper filings, but it doesn't appear that there was a hearing. Am I incorrect? Like an evidentiary hearing?
Correct. There was no evidentiary hearing. The court didn't take testimony. It took written statements from many family members and written documents, but there was not an evidentiary hearing or testimony.
In the adjudication on the merits, again, what were those claims that were decided in Washington?
The claim was essentially that they were seeking a protective order protecting Alma and basically a restraining order keeping Margaret from obtaining Alma's property. It was just a question of whether that was appropriate at the time. And Alma, essentially, as I understand it, the Washington law and standard And there's a case that the court there cited in the decision that there's a higher standard for that particular issue in Washington. I think clear and convincing may be the standard that it was. I had to have that in front of me, but whether she was unable completely to manage her own finances at that point and make any decisions. And
do any of your claims that relate to, not accounting for the funds and spending her mother's funds on for her own personal benefit, do they relate to actions that occurred before that Washington case was dismissed? Or are those all actions that occurred after the dismissal?
Well, while that case was pending, Margaret Goldizen was actually restrained from contact with her mother or having any access to those funds. So while she had taken some action to gain access to the funds, she hadn't spent them yet. She had gotten her name on the accounts. Alma had signed the deeds, but the bulk of what occurred with actually converting those funds had not occurred.
Thank you.
Any other questions from the panel? You have a minute left. You can either use it or waive it, counsel.
Well, we just asked the court very quickly summarize. This is a very lengthy record and a very lengthy brief, and I take note of the appellant's counsel's statement that we didn't respond to the facts. I feel like we did as much as is necessary. The purpose of this proceeding is not to get into a tit for tat back and forth about the evidence and what was more credible. We'd ask the court to use the proper standard, not reweigh evidence, not judge credibility and determine something different than what the district court, who spent many hours with these witnesses and with the evidence, and decide in favor of our client, the appellee. Thank you.
Thank you, counsel. Mr. Rombaud, you have reserved 5 minutes for rebuttal.
Thank you very much. I'll go in the order these issues were raised by the courts. As to the issue of the guardian ad litem, this arose, as I'm sure Ms. Richards will acknowledge, out of a failed mediation attempt. The Honorable Jerome P. Homer from Salina, senior judge there, still practicing, but also as a mediator, concluded, having attempted to mediate this, that it could not be mediated. Reasons related, of course, to the capacity of AB, suggested that he make a recommendation to the court about someone who should be appointed. And the record, volume 1, page 139, will indicate that the hearing was continued for purposes of status, as the parties may, quote, continue to identify mutually acceptable nominees as guardian or conservator for the plaintiff. That's what we thought. That's in the journal. That's what the court determined, and that's what we thought would happen. They denied our motion for a Rule 35 examination, but it was my understanding that Catherine Kraft would be appointed as a guardian ad litem for the plaintiff. And indeed,
counsel, assuming that this is properly before us, so Ms. Kraft was appointed as substitute counsel and not guardian ad litem. How did that prejudice your case or your client?
When the case came on for hearing, Ms. Kraft as plaintiff, end quote, was called. And Ms. Kraft, as the record will reveal, and this is described in our brief, had no information as to the allegations contained in the petition. She had no concrete knowledge that these allegations were true. In fact, she agreed that the record would indicate that our denial of those allegations was at least as persuasive as the allegations themselves. She did not.
The district court was aware, of course, that Ms. Kraft had been appointed subsequent, as the proceedings were ongoing, right? That
Sure.
Ms. Kraft did not have
Sure.
a relationship previous.
I understand that, but if we don't have a guardian ad litem, and if we don't have a person that can support their allegations in front of the court, and the case came on for hearing, the case fails. You can't have it both ways. Which, if she was just a plaintiff, then her testimony on direct and cross would indicate that she failed in her proof, and admitted as much on the record. So if indeed she's the plaintiff, then we should be entitled to see evidence from her that would entitle her to the relief she was requested in the petition, but she was not able to support that. I don't think you give her a bye on the grounds that she was just appointed. If she was a guardian ad litem, perhaps there'd be some reason as to why she wouldn't have concrete evidence of that, because she hadn't done an investigation yet. But anyway, my time dwindles.
Quick question, and Judge Warner, don't count this against him. What when somebody sues as next friend, they don't necessarily know what the issues of the plaintiff are. How is that different? And we do that fairly often and see those kinds of cases very often. How is that different from this scenario?
Well, indeed, when you bring an action as an next friend, you're responsible for assuming the burden and meeting that burden of proof, Your Honor. I think if the next friend fails to do that, then the petition fails.
Well, but they may not have personal knowledge of what's going on.
Personal knowledge or evidence of other people that do have knowledge or documents, witnesses, some concrete support for your allegations. Whether or not you have personal knowledge or know of other people who do, none of that was able to be marshaled or put before the court by Ms. Kraft.
Okay, well, I see that as a little bit of a different issue, but you've answered my question. Go on.
Thank you. And then, again, Ms. Richards and I have an excellent relationship. We'll continue to have one, but Ms. Richards, says that it's not in fact true that these children brought suit against my clients. In fact, the same situation pertained, as you can ascertain, in the Washington case, wherein Ms. Goldizen was actively asserting statements in that case against the petition she purportedly brought against Margaret Goldizen in that case. And those exhibits are 7, 8, 75, 96, typewritten statements, handwritten, written statements, where she was opposing the action supposedly brought against her. With respect to that, the res judicata or claim preclusion issue, on the record, indirect, both Mary Poulin and Mr. Belmore admitted that the allegations that they had brought in the state of Washington, in fact, they were the ones bringing that action, were substantially similar to the allegations that they brought in this case. And indeed, on June 1, 2016, Ms. AB had already granted a joint tenancy interest in the subject property in Dickinson County on March 27, 2016, to my client. That was discussed in that Washington case, and that issue is included in the determination from which they brought no appeal. I do believe that those issues were concluded in the state of Washington. Maybe there was no hearing, but there was 750 pages of documents submitted, and there was no appeal taken. And so I do believe the plaintiffs in that case, or their witnesses, admitted those claims were substantially similar. And therefore,
Counsel, we're at the end of our time, even with a little bit of extra time as requested by Judge Walker. But if you want to take 30 seconds and wrap up, you can go on ahead and do that.
Yes, as to the standard, Your Honor, the Ms. Cresto was a 2015 case, In re Estate of Moore is a 2017 case. It's clear that to overcome the presumption of validity of a deed or a grant of an interest in a bank account, there has to be clear and convincing evidence. There was clear, convincing, objective evidence on the issue in this case. It wasn't simply just competency, but it was also that AB was not vulnerable. She was not subject to undue influence. The plaintiff's own expert stated that she didn't think anyone in the world could coach AB to do something that she didn't want to do. That was Dr. Christine Durrett. So those issues, whether you call them competency or not, they include and are specifically addressed to the whole issue of undue influence and coercion against her will. And I believe the evidence in that regard was concrete, it was substantial, that there is just not a preponderance of evidence, much less clear and convincing evidence that my client did anything improper in this case. And finally, on the question of the power of attorney.
Counsel, we're at time right now. But thank you very much for your argument today.
Thank you.
And I want to thank both attorneys for your arguments and your extensive briefing on this case. We will take the matter under advisement, and we'll get an opinion out just as soon as we're able.